Is it on? Yeah, it is. So, yeah, the topic was open innovation. Does IP get in the way? Leo was so kind to explain a little bit what open innovation is. It's the idea that you do not do your R&D inside the company on your own, thinking that you can do everything yourself. But it's focusing on what you really can do very well yourself, what your core competencies are, and what people outside your company can do better than you, know better than you, and what you can use to jointly create a new product or go to market. So it requires that knowledge flows from your company to another company, to another R&D institute, and vice versa. Which, if you see that on the screen, feels contrary to intellectual property, which by definition is supposed to create a barrier around what you're doing in your company, around your knowledge. So there are two conflicting principles. But every company, every economic operator is somehow looking to have a competitive advantage. And what Leo said about the companies that are lobbying to have patentless or patent empty spaces where they can operate, they do that because they can gain a competitive advantage in another way. I think Google is one of those examples. They are very selective in what they're giving away and what they're keeping for themselves. So if those companies are lobbying, you need to ask the question, what exactly do they keep for themselves and why are they lobbying in a certain area? So they have no patents anymore. If you look at aspects of competitive advantage, there are basically 4 characteristics you need to have. If some advantage becomes a competitive advantage, it needs to be something of value. Others need to be interested in it and be willing to pay for it somehow. It can be that you're having an extremely efficient supply chain, but it can also be knowledge, technology that can make products better. It needs to be rare. If it's a commodity, there's no advantage. Everybody has what you think is important. You're not having an advantage. It also needs to be non-substitutable, meaning that there's no alternative to your advantage. In technology, it's fairly easy, I think. You have a certain technology. There needs to be no alternative technology that has the same advantages as yours. If you have those 3 as an advantage, you have a competitive advantage. But still, others can learn from you, can understand why you're having a certain advantage and catch up on you. So you need something that makes that temporary, short-term advantage a sustainable advantage. My strong point of view is that for that you need to have IPR. You need to have patents, copyrights, and know-how protection, trademarks, the whole range of rights to make sure that you can convert your advantage into a sustainable long-term advantage. And what open innovation does, it creates innovation, it creates new technology, and it builds relationships. Relationships are actually pretty hard to copy, and takes a long time to really build a relationship. But innovation in itself, once your product is out on the market, copycats are around, and it's really, really easy to copy the stuff. So those open innovation and IPR are going to be complementary, because in the end, nobody does an open innovation just for fun. Everybody does it because they want to gain something. So what do you need to do prior to going into open innovation? You do not just step in and say, oh, I'm willing to share everything. You make an analysis. You identify what exactly you're capable of, what are your capabilities, and what are you not. What are you lacking in terms of competencies? What exactly doesn't work, what you would like to work? You also need to make an inventory. What exactly do you have as know-how, knowledge in your company? It can very well be that there are pockets of knowledge in your company that you're just not utilizing. So you actually have the knowledge to build the competencies, you just forgot that there is some R&D team over there. It does happen in big companies that there are teams kind of lost in the organization. Can also be that one business unit has a certain technology that actually is very valuable, to the other business units, so you need to look around and see what's available. One of the examples in my previous job in Freescale was actually one business unit was making microcontrollers. I'm assuming nobody is familiar with microcontrollers. Microcontrollers are extremely complex products. They contain a little part called the core, which actually does the mathematical operations. If you're looking at different kind of semiconductor products that, for example, just provide a lot of current and power to lift in cars your window or control the brakes, more and more they're using these kind of cores to actually correct errors in the transistors to make sure that the power is really controlled in a good way. So if those two business units do not talk to each other, the one business unit could very well be saying that they need to have that core in their power product and see that there's a gap in their competencies which is actually available inside your company. So once you've made that inventory, you need to think, what do I do with it? What are the trade-offs if I go to open innovation and share, or keep it somehow protected with my intellectual property rights, and do not bring it into an open innovation collaboration. And then you need to choose the model you want to use for your intellectual property. Do I want to keep it somehow exclusive? Do I want to be able to have a price premium in the market? Or do I not share the knowledge, but I'm willing to open up things in exchange for some benefits, financial or non-financial trade technologies, rather than doing really an open innovation. So you choose the mechanisms at the last step to create the competencies that you're lacking, or create or get access to them. Once you've chosen it, I'm assuming that your selection has been that you need open innovation as a means to get access to certain competencies that you're lacking. You need to set up a partnership. And partnerships, the ones I've seen failing spectacularly, always failed because of a lack of trust among the partners and a lack of objective. It can very well be that you start with a common objective, but somewhere a couple of years later things changed and the objective suddenly is not a shared one anymore, and everybody starts pursuing their own goals. So you need to follow these steps. You need to identify a strategic objective that you're having and you're hoping that the others could be having as well. You come with your knowledge inventory and you divide it between the things you really want to keep for your own and the things that you're willing to share and open up, and the value model that you're going to use for both to exploit the knowledge. You also need to define, before you set it up, you somehow need to make value apparent to the partners in the project. So you need to decide or somehow think, put yourself in the place of the others. What could be the outside value of my knowledge? What could somebody else be interested in to trade off? In semiconductors, it's fairly easy. You have a computer chip that does calculations, there's software on top. The computer chip with the software is used in some application, actually in Leo's products, quite a lot. So you can understand that there's some interaction between the chip and the software. So for a software maker, there's value in knowing how a chip works and vice versa. For both, there's value in knowing where it's going to be used and what's important to the people using actually the chip and the software, and vice versa. For base station manufacturers, it's very important to know how a chip works, how it works efficiently, because it needs to do a lot of calculations in parallel. And so what they need to tell to the semiconductor companies and the software companies. Then you need to find the partners, and that's the hard one. Finding suitable partners is really hard because typically people tend to keep things secret. So you need to have your information channels, which typically tend to be salespeople, marketing people. They know the market better than IP departments. And you need to approach them. And then it's easy because you negotiate and start. But that's where the intellectual property actually does get into way. It's not because they are, from a commercial strategy perspective, somehow blocking. It's because the way we negotiate these agreements, the culture that's behind it, that always makes IPR the most hard and difficult point, I think, to negotiate. Because companies, operators have different strategies. They also have different objectives. There are a lot of legal constraints, and hopefully Leo can lobby a little bit more in Europe to get those out of the way. But especially in Europe, there's a lot of regulation about access to IP, things that R&D institutes can do or can't do. R&D institutes need to get some kind of market price for their know-how and their IPR, so they cannot give it below market, and you enter into these discussions. And there's something since I'm named Frodo, is called by me the smoke syndrome, which really makes it very hard. And that's this one. Everybody likes to sit on its hoard, its IPR, and not give it away. It's like a dragon guarding the gold and not willing to share. It's a culture that's present in almost every company I've seen, and even the ones that have a nice outside appearance in the software industry, that they're sharing a lot, they always keep a part for themselves and they're not willing to share. And the things that they're sharing, they're still trying to heavily control how it's being used. And there are causes for it. One is the winning lottery ticket. I've done a lot of negotiations in France with, I don't know if people are familiar with the public research infrastructure there, but there is a government-run organization called CNRS, which at the time had a couple of pharma patents where they made a lot of money. And now they're assuming that every patent coming out of that organization is potentially going to make them hundreds of millions. So they're never ever going to share things easily. They always want to know, hopefully, things back, because it could potentially in the future be the winning lottery ticket. There's also a thing, I think we all do it, we overestimate the value of what we do and underestimate what the others are doing. We all think that our IPR is the best and that everybody else needs to somehow be paying a lot, either in cash or in giving things back. There are internal things. Siloed organizations do not help in companies, and that's something where you negotiate. You need to try to break through. Law departments tend to be silos, and IPR people even more. I think most IPR people, especially the patent people, do not like to be called or be bothered. They like to draft their patents, prosecute them, write their memos and stuff, and not really, especially not to the outside world. And they do not like to be bothered. There are other things, lack of business strategy. Not every company has a very well-defined business strategy, what they want. They just know we want something, but haven't really an idea what. Which is actually very hard to define business strategy. But if you do not have one, negotiating is going to be very hard if you have the other problems as well. And a lack of trust. It depends on the industry, but there are industries where lack of trust is somehow an industry characteristic. I would say automotive being one. There's a very hard top-down kind of things, and partners in the auto industry do not really trust each other. So you kind of need to find solutions. I think the number one solution has always been try to understand where the other is coming from and why he's behaving in that way. It's not always easy and sometimes annoying. You need to be flexible as well. You cannot go into these kind of projects and just say, this is what I want. You always need to trade off and find alternatives to what you want, second best alternatives. And you need to make, that's more of a sales pitch. You need to make visible to the others what you're giving. If you're not giving things, then it appears as you're being annoying. If you're giving things away without making value visible, nobody will understand that it had value for you and that you're actually giving something, and that they should feel obliged to give something back as well. You also need to propose something that you do not care that much about, but that they care about, so that when you give it away, everybody kind of wins. And you need to build trust. Trust is really, it has nothing to do with legal stuff, but it is essential. If you're negotiating, start taking the guys, the other team, out for dinner or something. Make them feel comfortable, and that lowers levels. Make sure you see them in person as well, and do not do those negotiations over the phone. It builds trust, and typically you get a lot of information as to why they're behaving. So you get the understanding. You can also make value visible to them, and you suddenly start understanding why they are sitting on something and not willing to share that, even though you identified it as being the gap in your competencies. So then you need to structure it somehow. You need to have a contract. I've seen a couple of collaborations where there were no contracts. That tends to be a recipe for problems later on, because there's always, you're interacting, so there's always a point in time where you run into problems, especially at the patent side. People co-inventing stuff. It doesn't get very far, so you need to contractualize it. You need to start with defining whatever the objective is, and you need to make sure that the contract is a balanced one. Disbalanced contracts can happen, tend to be, my experience, in the supply chain, if you have a vertical innovation product, so it's all the supplier chain that kind of collaborates, where the top of the supply chain pushes hard down to accept certain conditions that actually down into the supply chain are felt as being unreasonable, and only accepted because it's your big client that's asking for it. You need to structure the contracts. I think that's pretty evident, but IPR, antitrust, the operational side, not to forget, who decides, what's the timeline of these things, what do we expect at the end, what are the objectives, the deliverables. And don't forget the one which actually is going to destroy a bit of the trust, typically, if not completely. What if it doesn't work? How do we separate? And discussing a divorce when you want to get married is really hard. But you need to think that through. And you really need to think on the operational side. You need to make sure that all partners in a project are actually going to contribute and collaborate. And you do not have some freeloading partner that actually does take the results and just sits in the project to get the information. And I've seen that not so much in R&D projects, but in standardization organizations, especially the private consortia. There are companies that tend to want to sit in the consortium, but not do that much, but in the end get access to the standard. And you know, of course, together with what does it, if it doesn't work according to plan, at some point in time, even if it goes to plan, your project ends, and you need to decide how you wind it down, and especially on the IPR side, what people can do later on. And it does involve, especially for the lawyers in the room, that you engage with the business and the operational people. And as a lawyer, you're not sitting with your predefined policies, but that you really talk to those people, listen to them, and get their input as to how you need to translate that into your legal language. So that was my presentation, and now it's your turn, I think, to go out and do projects and structure them.
Thank you, that was really helpful. Thanks for sharing your point of view with us. We still don't have our third speaker, Alice, with us here, so I think it's better we proceed with the questions if you have any.
If you allow me, I would like to react to some points because I thought they were really, really interesting.
Yeah, sure.
Before we open it up, because we have enough time anyway. So first of all, I found it very interesting, of course, that you say that companies don't want to share their IP, they want to keep it in-house and so on. And that's, of course, generally the case, unless a company can use it in a specific way. And I think the core that the company wants to do is really to build an open innovation system around the company, you know, to have like-minded companies, etc., which can contribute. And there, sometimes it may be useful to share the IP. We have an example at Nokia, where we actually looked at all the IP and thought, so which is the IP which we don't need, which is kind of interesting, which would be useful to develop, develop the technology further, to market it, etc. But it's not really core of our business, but it's close to our business. So what we did is we have, out of 1,000 patents, selected 100 that we have given for free to individuals, companies, and we have helped them to create startups on that basis. So that was, of course, fantastic, because that meant that they were developing kind of technology that was very close to ours, and they were very friendly towards us, and they became part of our innovation ecosystem. Another possibility is, of course, to create an open platform and to attract others to it, especially in the digitized, networked world. At some point, if you manage to really build this solution that everybody wants to be on, you're the king. So, and as digitization, connectivity, etc., will come to other sectors, it will penetrate more and more all sectors of the economy. Perhaps you will, at some point, get to that as well. And there's more examples. I mean, as Nokia, we underwent quite a strong process of transformation in the last few years. I mean, that's not new to us. We are a 150-year-old company. We have transformed ourselves many, many times. In the last few years, at some stage, we had to lay off some of our workforce, and we thought, what can we do to not lose the creativity, to lose the innovation around us, not to lose the innovation in the cities where we are active? So we have provided them, instead of just losing them, we have provided them with startup funding and access to IP and access to other assets. And they have set up their own enterprise. So about 1,000 companies have been born like that. Of course, in areas where we did business as well, and it's of course then just increasing again your ecosystem. Another example is, of course, where open innovation is also very strong, is if you are under cost pressure, or if you want to bring young blood into the company, or things that you lack. What we have done together with other companies is we have set up a project called Demola together with universities, which consists in the idea that as a company you bring a challenge to a team of students that can be put together representing different skills, and then that they together, interdisciplinary, perhaps with one or two experts from the company, develop the solutions that you want to have. And that has worked extremely well. So this Demola concept has expanded through Finland, but also to other countries now, because it's a very practical way to get your technology challenge solved. It can be designed, it can involve programmers, it can involve, of course, lawyers, etc. And in fact, I don't know the latest statistics, but the idea is in the end that the company buys from the students the solution they have developed. And I think in about 2/3 to 90% of the cases, the business has actually then bought the solutions that the students have developed. So really also enhancing a kind of mindset of creativity in the students, and getting them getting early interest for the business, for what you do.
Yeah, I was wondering what I was going to react. No, that's very interesting and very hopeful, but it does depend on the industry. Freescale, for example, operated partly in the telecom industry, where this is fairly common, but also in the auto industry, where the attitude is completely the opposite. It's a very closed, very defensive, sitting on your IPR. And even if you're collaborating, especially making sure that you do not give any access to your IPR to the extent that you can.
Any questions?
I guess I'll start. First of all, I want to thank both you and and Sean, as far as sharing your experiences with your company and how the various new developments are occurring, and especially fascinated with one, Sean, how your the timing, and we'll talk a little bit later about how you've kind of taken off with the patenting post State Street Bank and kind of post Alice. So I want to talk a little bit about that later. But your two presentations are very complimentary as well, which I really enjoyed, that we could see, I guess, the company perspective, and I guess, Frodo, you're more of independent, so you've handled different things for various companies. And Frodo touched a lot on probably most of my questions, which were what are the problems associated with these types of partnerships and how to define it, and how to, for example, one question would be, how do you decide if you have technology that may or may not be something that's part of this group? Do you just file on it first and then come clean with the group and sort of share it to decide whether you want to contribute it? Or do you sort of open it up to the group and potentially then disclose your invention? Obviously, you have NDAs and stuff to protect yourself. But from your perspective, Frodo, just a simple question. What are some of the problems that you've seen, and how have you been able to deal with those problems?
Ooh, that's a fairly open question. You get the lawyer's answer. It depends. No, there are a lot of things. What I've seen is typically you do not enter in this with a, what do you say, a plan that you had 5 years before. It's kind of the outside environment, technology developments that kind of force you to go look for partners with your existing stuff. If you have your company set up properly, I think, a little bit what Sean said, you will have already an invention harvesting program, and whatever knowledge is in your company should have gone through that process. I was lucky enough to work in Freescale where we had this kind of thing. There was really a hard push that everything that was patentable would have be submitted in the system, evaluated, and decided, is this potentially patentable or not. So you should always have been in an early stage. And then, of course, the real problem actually always started after you started the collaboration and there were joint innovations. If you have your agreements worked out the way they should work, you have a model. I'm not saying that it's a nice model, but there is a model. And I think that was the most visible and difficult thing, joint inventions, because you always lose with joint inventions. The only way to solve that is separating the invention somehow in two different patents. That's the only way. But I think that was the most recurring and most difficult one. How do we handle joint inventions in an open innovation project? I don't know. Every country has its own rules, and to me it boils down to either you are not allowed to enforce on your own the patent, which means you're depending on the co-owners and they will never collaborate if you want to enforce against the infringer, or you can enforce but then also grant licenses, so whoever you're going to enforce against is going to run to one of the other co-owners and ask for a license. Plus every country has their own rules, so that's a mess, and that's one of the things I always try to avoid, those kind of situations, and make sure that you have documented who exactly invented what and how can we separate the contribution, because typically one of the companies comes with the broad idea and the other improves on it, so how can we separate those in separate rights and not have that mixture?
Yes, very good points. And I just want to make some publicity because actually we have a trade association where all the technology companies, all the global technologies companies are members, but also the ICT associations throughout Europe. It's called Digital Europe, and they have developed, they call it MCARD, so the Model Consortium Agreement for R&D. And that is very good because there you get good advice on, you know, how much access you should have to the results, to to the R&D results. How wide should the access be? Can also, if you are part of a group of companies, all the entities have access to the results, and then it addresses also this IP problem, which is really a problem for us as well, because it sounds nice to have joint ownership of IP, and that's very often something that policymakers put as a default clause, or that universities think it's good, because then they think they're always on board of the boat, whatever you do as a company. But in fact, it's not good, especially not in our sector, where we have lots of patents and we enter into cross-licensing agreements with other big companies, and then we're talking about hundreds or thousands of patents, and then we cannot possibly involve always the joint owners of a few patents and ask them perhaps for permission or provide them some royalties on that. Then those patents will just simply be excluded from the cross-licensing agreements, and nothing benefits from that. So it's always much better to clearly ascertain who has contributed what to the research, and then even if some have contributed something together and it's not easy to split it, at least you should make clear who is the owner of the patent and avoid joint ownership.
And the next question, please.
Great, thanks. Just a quick observation on joint ownership. Another option is just not to file, unless it's fundamentally important to the business, which is certainly a strategy we have employed on occasion. My actual question, though, is more towards Leo. When you were talking around the contribution of, say, 100 patents to people to allow them to develop, and also around your accelerator program that you have for startups. You may not be able to tell me this, but I'm just wondering in terms of what protections do you have in place to protect Nokia around those arrangements? For example, in terms of the contribution of 100 patents, do you get a license back to anything that's generated? Is it just purely done for the good of man? Those, I mean, fully understand if you can't disclose that for contractual reasons, but I'm just interested.
Yeah, it's very much case by case. It's very much, do we still need the IP? Do we provide a license, or do we actually really transfer the whole IP of the patent? I would have to ask my colleagues that have worked out the details in those areas, but it's really on a case by case basis.
I just wanted to comment on the first thing. Not filing typically is not an option because you have the others that have a right. And my experience is that if you say that you do not want to file, they say they do want to file, and they want to take your ownership. And that typically has other complications with it. At least in the companies I worked in, assigning ownership of a patent, you typically go very high up into the organization to get approval. That gets nasty questions. Why do we give away patents for free? So that typically is not an option.
Do we have any other questions? Apparently not. So, if you have something to add, looking at them, no, okay. So it seems that we're done. I would like to thank to our speakers for their informative and interesting presentations, and for the active participation of the audience. I would like to give your memento.
Just a quick update. Alice Hume, she actually lost her bag in the airport. She's actually still on her way. We'll try to fit her in our next session, or the last one. Hopefully she can join us.
Not her day, apparently.
And now we'll head for our lunch break. The lunch will take place at the Pebblewood Corner, which is just beside the registration center. As you have all come across, just beside the registration center. It's called the Pebblewood Corner. and we will resume the fourth session at 2:45 p.m. Thank you very much.